Last lecture we have discussed part one of the bar bench relation, and in that lecture we have discussed regarding introductory analysis and the responsibilities of war, also the responsibility of the bench. And in the present lecture, that is part 2, in regards to bar bench relation, we would like to discuss cooperative interaction between lawyers and judges. As administration of justice is the sacred duty of both the lawyers and the judges, speedy and just delivery of justice to the litigants is only possible with cooperative interaction between the lawyers and judges. The canons of professional ethics compel the professional to strictly adhere to the basic ethical principles while pursuing the profession. As practice of law is coming within the definition and meaning of profession, so every member of the community should strictly adhere to the canons of legal ethics. No doubt, the Advocates Act 1961 and the Bar Council of India rules provide various provisions and regulations on legal ethics, but their ultimate realization and manifestation entirely depends with the lawyers. So the lawyers bear the sole responsibility to uphold the legal ethics for speedy and just administration of justice. So, to fulfill the requirements of legal ethics and to achieve the conditions of justice, the lawyers should always show an attitude of cooperation towards the judges. Conflicting and confusing attitude in the manner of presentation and proceedings will lead to arrogant and antagonistic reactions from the judges. So the lawyers should follow the following norms and procedures, such as lawyers should be polite and gentle in their manner of presentation. They should be calm and cool in their arguments and examination of witnesses. Also, they should be careful and cautious in their language in the petition, and also during its oral presentation. Besides, they should not cite any conflicting and confusing views. They should take utmost care in citing leading decisions and provisions of the statutes in case of any wrongful presentation or of any wrongful statement of the fact should immediately apologize and withdraw the sham. They should avoid to their best not to react on any remark of the judges. They should take care not to become emotional and sensitive in any proceeding. Further, they should not restore themselves to any fraudulent deals and negotiations. They should be free and frank and should not adopt any unfamiliar and indirect methods to influence the judges. To present their genuine grievances, they can make a request for an audience with judges by following the above norms and procedures. There will be less conflict and an atmosphere of cooperation will prevail not only inside the court, also between the lawyers and judges. Shame is also expected from the fraternity of judges in comparison to the lawyers. The judges are more experienced and learned in the manners and procedure of the court, so they are expected to show their wisdom and intelligent in handling the lawyers in judicial proceedings. The following requirements are being expected from the judges to minimize and to avoid conflicting situations inside the court of a healthy to make possible of a healthy and cooperative atmosphere, which is the exact need for the proper administration of justice. So judges should avoid undue interference. Lawyer is well prepared and is making an oral presentation of his case. There should be no interruption in the trial of a case to promote expedition and to prevent repetition or unnecessary waste of time. The judges should be considerate and cautious towards the lawyers. They should avoid a controversial manner or tone. A judge should have patience and gravity of hearing. He should give the lawyer fullest opportunity to present the case. A judge should have a receptive and heated mind and should not form any opinion on the merit of a case till he has heard the parties. A judge should refresh passion as in the words of George Sherwood, where passion is allowed to prevail, the judgment is dethroned. So it is rightly said that a judge must not allow himself to be subjected to any influence other than the influence of the law and justice of the cause. Administration of justice is only possible with cooperative interaction between the lawyers and judges. As to the nature of duties and functions to be discharged by both, they should consist of their language and manner in the proceedings of a case, should control their respective temper, and should try to avoid harsh and heated arguments. Actually, judges and lawyers are complementary to each other. Proper administration of justice is only possible if both the judges and lawyers will be conscious of each other's duties and responsibilities towards the society. It further requires a cordial relation between the two. Cordial relation between the lawyer and judges odds the fulfillment of the following conditions. It is the duty of the lawyer to inform the court as to the law and facts of the case. The lawyer should present his line of arguments in the most judicious manner. He must avoid uncautious conduct and of using insulting language. Further, a lawyer should not question the authority of a judge and should not act in a manner of suppressing the facts to obtain favorable orders. Same is required from the judges. A judge must not allow himself to be subjected to any influence. He must be impartial and must do everything for justice. He must discharge his duties without fear or favor, affection or ill will. A judge should give a patience and cautious hearing to a lawyer in his arguments. No doubt, the above discussed paragraphs rightly expose the desired norms for a proper cooperative interaction between the lawyers and judges in the administration of justice. But the real beginning rests with the lawyers. As stated, the attitude of the lawyers towards the court should be one of uniform respect, whatever the status of the court, whatever the lawyer's private opinion may be of the lack of intelligence or learning of the presiding officer, he must not show it in his behavior, because one of his foremost duties is to uphold the dignity of the judiciary as an institution. So, in that connection, we would like to discuss certain important leading cases in relation to bar and bench relation. And the first important leading case that we would like to discuss is Muhammad Safi versus Qadir Baksh, decided by the Lahore High Court in 1949, and in the fact of the case under Section 145 of the Criminal Procedure, an order of temporary injunction passed by the subordinate judge restraining the first party not to proceed with the proceeding before the magistrate. As soon as the order was produced, the magistrate lost his temper, got up from the chair, and addressed the advocate of the second party as follows: Police order passed by the police sub-judge and secured by a police lawyer. From where have you come? What is your standing? You seem to know nothing of law. You are playing with fire. And the consequences of playing with fire was obvious. The magistrate was held guilty of the contempt of court. And now we would like to discuss another important leading case, that is Jones versus National Coal Board in 1957, decided by the Queen's Bench. So yeah, sir, you valet and English judge talk too much, ask too many questions, one after another, to the witnesses in the dock and to counsels while making submissions. So, in the very appeal before the Queen's Bench, in this important leading case, Jones versus National Coal Board in 1957, and in the very appeal and cross appeal were made against this judgment. Both parties made the grievance that the interruption by the judge prevented the parties from having a fair trial. The judge asked to resign, and he did resign. He was able and intelligent, but he asked too many questions. And also in that connection, we would like to discuss another important leading case, that is Chancery Court case, where Sir Charles Russell appeared before a judge of the Chancery Court. The judge, who did not know Russell, rudely interpreted him again and again. Then Russell threw the brief and said, "My lord, what may be the manners of the place whence you come? I know not, but I do know that on this side the judge treat the lawyer as gentleman, and as long as I am a lawyer, I will submit to be treated in no other way." Without more, he left the court. The judge hastily sent a messenger after him, and when he came back, humbly apologized and interrupted no more. And now we would like to discuss in that connection another important leading case, and that is Lalit Mohan versus Advocate General in 1957, decided by the Supreme Court, where a legal practitioner imputed partiality and unfairness against the munship in open court. He suggested that the munship followed no principles in his order. Here the lawyer overstepped his limit of propriety and was held to be guilty. And finally, we would like to discuss one of the important speeches delivered by Justice Nageshwar Prasad in connection to bar and bench relation. So, in that very speech, when a judge loses his temper or indulges in some impolite behavior towards the lawyer, exhibits impatience at the cross examination or speech, it has to be tactfully but firmly handled. The lawyer should not subjugate his self respect to please the judge. He should find ways of asserting his right and self respect, and the beauty of his art lies in choosing with fitted words to convey his resentment and to carry out his duties in spite of the impediments thrown by the judge. So, these are the important leading cases. And the last one, the very speech delivered by Justice Nageshwar Prasad in connection to bar and bench relation. And by this we conclude our lecture, and that is the part 2 of bar bench relation.